Hello everyone, my name is Tin Sin. Before discussing the legal issues surrounding Islamic banking legal documentation, it is important to first understand the significance of legal documentation within the Islamic banking framework. The concept of legal documentation in Islamic finance can be traced back to the term al-saq, which literally refers to written documents evidencing a transaction. This demonstrates that proper documentation has long been recognized as an important aspect of commercial dealings in Islam. Islamic banking and finance is fundamentally based on the concept of muamalat, which governs commercial and financial transactions in accordance with Sharia principles. Similar to conventional banking, legal documentation serves as crucial evidence that records the rights, obligations, and responsibilities of the contracting parties. However, Islamic banking documentation serves a broader function than conventional banking documentation. Besides ensuring legal enforceability, it must also ensure compliance with Sharia principles. In particular, Islamic banking transactions must avoid prohibited elements such as riba, interest, gara, uncertainty, and maisir, gambling. The importance of reducing financial transactions into writing is also expressly recognized in Islam. This can be seen in Surah Al-Baqarah verse 282, which encourages parties involved in debt transactions to record their agreements in writing. Nevertheless, despite its significance, various legal issues may arise from the terms and conditions contained in Islamic banking agreements. In the following discussions, we will examine the key legal issues pertaining to the terms and conditions in Islamic banking legal documentation. Moving on to the first legal issues, this issue arises because Islamic banking operates within two different frameworks simultaneously. On one hand, it must comply with Sharia principles under fiqh muamalat, which emphasizes maqasid al-Sharia, namely the protection of religion, life, intellect, lineage, and property. On the other hand, Islamic banking documentation is often drafted using principles derived from English common law, which focus on contractual certainty, enforceability, and commercial risk allocation. This issue was illustrated in Arab-Malaysian Finance Berhad versus Taman Ehsan Jaya Sendran Berhad. The bank sought to recover the full deferred sale price under a buy di taman ajil facility. The court adopted a substance over form approach and held that judges should look beyond the labels and drafting of the agreements. Although the transaction was structured as a sale, the court expressed concern that its practical effect resembled a conventional money lending. As a result, the court refused to strictly enforce certain terms that allowed the bank to recover unearned profits upon default. Furthermore, this dual framework friction can also be seen through the corporate status paradox. Although Islamic banks present themselves as Sharia-compliant institutions, legally they remain corporations under secular company law. As artificial legal persons, corporations can possess legal rights and obligations, but do not possess religious conscience in the same way as natural persons. Therefore, courts generally enforce Islamic banking documentation through principles of contract and corporate law rather than purely religious obligations. Nevertheless, this does not mean that Sharia principles are irrelevant. In Malaysia, the Sharia Advisory Council under the Central Bank of Malaysia Act 2009 plays a significant role in ensuring that Islamic banking products remain Sharia compliant. Therefore, the key challenge is to harmonize Sharia principles with modern commercial and legal requirements while maintaining both religious legitimacy and legal enforceability.
Good morning, doctor. My name is Francis Goyenshi. My metric number is 301280. Today, I'm going to discuss the second key legal issue in Islamic banking documentation, which is the equitable intervention and the rewriting of terms. Although the Islamic financing contracts such as the Murabaha, BBA, and Tawarruk are structured as the Sharia-compliant sale transaction, the civil court may apply the equitable principles and examine the commercial substance rather than the contractual form. Where the bank is viewed as a financier rather than a genuine seller, the transaction may be recharacterized as a financing facility. The courts may then invoke the doctrines such as the unjudged enrichment and the rule against penalty clauses to prevent the recovery of unearned profits or excessive default charges, limiting the bank to reasonable compensation and profit earned. In the case of Malayan Banking Berhad and Marilyn Ho Siok Lin, the court refused to enforce the full BBS sales price after the customer defaulted, holding that doing so would unjustly enrich the bank through the recovery of unearned future profits, relying on the Section 148 subsection 2 clause C of the Sarawak Land Code. The David Wong Jie exercised the equitable discretion and recalculated the bank's entitlement based on the principal sum and profit earned during the actual financing period. The case demonstrated the court's willingness to modify the financial consequences of the Islamic banking contracts in the interest of fairness. Conversion of the Islamic financing into conventional loan structures. A major concern is that the judicial reliance on equitable principles may transform the Islamic financing into conventional loan arrangement. In the case of Arab Malaysian Finance Berhad and Taman Insan Jaya Sendian Berhad and others, the Court of Appeal criticized the attempts to replace the agreed contractual terms with equitable formulas. Similarly, in the case such as the Afin Bank Berhad and Zulkifli Abdullah and Malayan Banking Berhad and Marilyn Hosolin treated unearned profit similarly to interest in conventional loans, blurring the distinction between the Sharia-compliant financing and conventional banking. In some situations, the court may even rely on Section 66 of the Contracts Act 1950 to restore only the principal sum, effectively converting the Islamic financing structure into an ordinary civil debt framework.
Unlike conventional banking, Islamic banking documents use asset-backed trade contracts, like BBA, to avoid riba. However, the Malaysian constitution forces all banking disputes into civil courts rather than the Sharia courts. Because the civil judges are trained in English common law, they often look past the Sharia structure. They recategorize distinct trade terms as a regular conventional loan wrapped in fancy words. In our present case, Datuk Nik Haji Mahmud versus Bank Islam Malaysia Berhad, the BBA contract terms require signing a property purchase and a property sale agreement simultaneously. When a customer defaulted and tried to cancel the contract, the High Court upheld the bank's charges. However, the judge explicitly ruled that executing these separate Sharia trading agreements was a mere formality. This reduced a mandatory religious trading requirement into simple administrative paperwork. Moving forward to our next case analysis of Bank Islam Malaysia Berhad versus Adnan Okmar, the bank foreclosed on land using a default clause in a BBA agreement. The customer argued that the civil court lacked jurisdiction over an Islamic contract. However, the court in this case firmly rejected this, ruling that a bank is a corporate body that legally has no religion and cannot under Sharia courts. The judge enforced the foreclosure strictly under the Civil Rule of Court Order 83 Rule 3, completely filtering out the Sharia dimension.
Additionally, the key legal issue treats is profit tenures and unearned profit clauses. In general rules, Islamic banking accelerations clauses allow the bank to demand immediate full payment after customer default. In BPA financing, the selling price includes both the principal amount and profit for the entire financing periods. However, a problem arises when the bank terminates the facility earlier but still claim profit for the remaining unexpired tenures. This creates unearned profit because the bank claims profit it has not actually earned. Such clauses may lead to unfairness and unjust enrichments by the bank. Besides, under Islamic finance principles, profit should only be earned for the actual financing period used. So, profit for the remaining unexpired period should be waived through rebate. Besides, in the Affin Bank Berhad versus Zulkifli bin Abdullah case, the defendant obtained a BBA financing facility and the financing was later restructured. The bank fixed the selling price for 25 years and the defendant made some earlier payments but later default. The bank sued to recover the full selling price, including the profit for the entire 25-year tenures. Then, the issue arose whether the bank could recover the entire profit margins for the full financing tenures after earlier terminations due to default. The claim was relied on the sections 7.02 of the property sale agreement, which accelerated payments upon default. And the court held that the bank claim was unjust and contrary to BBA financing principle because if the customer pay profit for the full tenure, they should receive the benefit of the full financing periods. Since the bank terminated the facility earlier, it could not claim profit for the remaining periods. So by allowing the claimed would let the banks earn double
profit on the same amount. So the profit for the unexpired tenors was considered as unearned profit, and the court rejected the bank claim for total profit, and the outstanding amount was recalculated based only on profit actually earned up to the judgment date. After that, there is the issues of reference to the Sharia Advisory Council (SSC), where the court consider whether the dispute should be referred to the Sharia Advisory Council. However, the judge refused to make the reference. This is because the judge stated that the issues involve interpretations and applications of contractual documents. Therefore, choosing Islamic finance does not change the applicable civil laws of Malaysia because enforcement of right remains governed by the civil law, the national land court, and the rules of the high court. So, the court held that the dispute was not about Sharia principle or the Islamic faith. The main issue concurred is the interpretations of terms like the sale price, default, and accelerations clauses in the contract. And the interpretations of the civil documents is the duty of the civil court. So, referring the matter always would amount to an adjudication of judicial responsibility.
Now we will discuss the statutory and regulatory safeguards that ensure Sharia compliance in Malaysia Islamic financial industry. The two main legislation are the Islamic Financial Service Act 2030 and the Central Bank of Malaysia Act 2009. Under Section 28 of IFSA, Islamic financial institutions must ensure that all their operation and activity comply with Sharia principle at all times. Bank Negara Malaysia is empowered to issue Sharia standard, while institutions also is required to establish Sharia committees, audit, and risk management system to monitor compliance. In case of non-compliance, IFSA also provide enforcement measures including corrective direction, penalties, even license revocation. Meanwhile, CBMA established the Sharia Advisory Council or SAC as the highest authority on Sharia matter in Islamic finance. For Islamic Finance Service Act 2013, we will discuss on the Section 28 of IFSA, which provide for financial institution required for operation, while Section 29 of IFSA for the issue of Sharia standard on Islamic finance that must be observed, and Section 18(1) Clause A, which give the power of the minister to revoke license if there is in non-compliance, and Section 167 and 16H with give the direction of Bank Negara Malaysia if there is a non-compliance for the Sharia Islamic and finance service matters. While the other hands for the Central Bank of Malaysia Act 2009, it involves Section 56 that introduced a mandatory reference to Sharia Advisory Councils, and Section 57 give the effects of Sharia Advisory Councils ruling if there been issue that is binding to the financial Islamic institution. Now we will discuss regarding the judicial recognition on the GRI resources case, which this case is important for Sharia Advisory Council that confirmed the appellant argued using Section 56 and 57 of CBMA, which they said that unconstitutional because they allegedly gave judicial power to Sharia Advisory Council. However, the federal court rejected the argument and held that Sharia Advisory Councils only determines Sharia principle, while the court remain responsible for deciding the facts and applying the law in civil matters. So here the court also emphasized that binding rulings by Sharia Advisory Councils help to ensure consistency and certainty in Islamic finance, which also give distinction between the roles of Sharia Advisory Councils and the roles of the CAT. So, in conclusion, Islamic banking legal documentation is essential in ensuring both legal enforceability and Sharia compliance, which three recommendations should be upheld, which is first, Islamic financial institutions need to improve drafting technique. Second, greater emphasize knowledge of Sharia among legal practitioners. And the third one is greater standardizations and uniformity clauses approved by Bank Negara Malaysia and guided by SSC. That's all from us. Thank you.